planning is really thinking about how you would like to look after your family when you die. It looks different for everybody. If you are a multi-generational farmer, it's going to look different to, say, a city doctor. If you're a young person, it's going to look different to an old person. But it's really just about thinking about how your family will be looked after when you're gone.
Not only that, it deals with how managing your affairs when you're alive. Estate planning involves, I guess, from the outset planning. It involves implementing documentation. It involves review of your circumstances of documentation, such as wills, which deals with your distribution of assets and a variety of other things. And you've got powers of attorneys, medical directives, which deal with your personal, financial, legal affairs and medical affairs while you're still alive.
It doesn't get easier if you delay thinking about your estate planning and there's some level of complexity. Let's say you've got estranged children, you've got a blended family, you're trying to think about how to pass on a family business. It's not easier on your deathbed. It's not easier when you're in hospital. And when you are well, when you have the energy, when you've got people that you can ask, you can control the outcome somewhat, that's why you should be doing your estate planning now. Estate planning is very important for young people who may not be very rich. That would be my example. Young people often have insurance, for example, in their superannuation. One case that I was involved with, a young person died in a workplace accident and his estate was paid quite a large amount of damages. He didn't have a will, and his wife, or his girlfriend and his mother were involved in a series of litigations over who got his estate. So he actually ended up being worth quite a lot. So young people can be needing to plan ahead as much as an older person or a wealthy person.
So if you die without a valid will, then your estate is subject to what's called the laws of intestacy. Now each state and jurisdiction differs as to how much is distributed, but essentially without having the will in place, your assets or anything you've accumulated during your lifetime might not go to your intended persons or beneficiaries, and it'll basically be split and divvied up as the court rules see fit.
For example, in South Australia, if you die without a will, your spouse gets the first $100,000. Then the rest of your estate is divided 50% to your surviving spouse and 50% to your children. And that's often not an outcome that people want. If you make a will, you can control the outcome.
So if you lose capacity without an enduring power of attorney or medical directive in place, one of your loved ones or family or friends would need to apply to a relevant state or territory's civil and administrative tribunal, and they need to essentially obtain some sort of guardianship order to deal and manage with your assets, because basically if you've lost capacity, if you've been knocked on the head, you're not able to manage a bank account, you're not able to pay your bills, you're not even able to call up Telstra, pay your phone bill. So they need to actually apply to the tribunal, obtain the order, just so they can maintain your lifestyle and look after you and maybe provide you with some sort of assistance. So it's probably best to generally have in place those sort of documents, because it just covers all bases. Even though in the worst event you think it might not happen, unfortunately it does way too often. So
without those important documents in place, your family at a time of great stress have to decide what to do. Usually they will go down to the state administrative and civil and administrative affairs tribunal to receive an order about guardianship or a financial order about how to look after your money. These might not be the people that you want to look after your medical decision making or your money. It's a difficult process. It's not expensive. It's as streamlined as a government department can make it, but it's not ideal. We recommend you revisit them every 3 to 5 years. A lot can happen in that time. The sorts of changes that we see people making are to do with executors and guardians. They make changes with gifting if assets have left an estate or have been acquired. They might be rethinking the needs of their beneficiaries at that time. Children have got older people have got, less able to look after themselves. You may have bought and sold assets, you may have changed your lifestyle significantly. So 3 to 5 years would be about what we recommend.
There could be specific reasons why you might need to update your estate planning documents. Say, for example, in divorce proceedings, say if you've divorced from your spouse, your will's no longer valid, so whatever gifting structure you have in place to your partner could be completely void. Similar to the previous question, you might buy a house, you might get married, you might have kids. Say if you have an old will in place and it's, basically different gifts are distributed elsewhere, as part of your plan, might not reflect your current intentions, and there might be also changes in the law as well. So it's usually worth just every few years having a look over it, at least calling your lawyer and saying, hey, is this all good? If not, move on with your life.
Who your beneficiaries are, who you want to look after, what your assets are and how you own them, whether you own them in your own name or if they're in a trust or a company or in superannuation. You want to think about how you give your gifts. Do you want to give the gifts to your family members directly, or are you thinking that you have vulnerable family members or they need protecting from third-party claimants, in which case you might think about a more sophisticated structure like a testamentary trust. Those would be the main things, but guardianship's another one. The people who play roles in your wills, I would say, are the number one consideration for most people and the ones that they get stuck on the most.
Essentially, legal capacity means you being able to make an informed decision about anything you'd like to make a direction or control over. So for example, if you couldn't consent to or understand or make an informed decision about preparing a will or signing off the will and understanding what that will means, those are sort of trigger markers as to what someone might consider as incapacity. So basically, do you feel well informed enough? Have you consented to it? Do you understand what you might be preparing or signing or entering into? Those are usually some things that take into account when we need to consider if someone has legal capacity or not to enter into an estate planning document such as a will.
Legal capacity can include a loss of mental capacity. It depends in different situations. For example, with powers of attorney, loss of legal capacity could be you're a bankrupt and therefore you can't be an attorney. So it differs. But I think what we're talking about is the loss of mental capacity. That's usually determined by a specialist, a doctor. But when that happens to you, you do need someone else to make decisions for you. Who those people will be, I think you would like to make that decision while you're able to make that decision. You don't want to leave it to your children to battle it out amongst themselves, or, as we discussed before, going to the Civil and Administrative Affairs Tribunal and having a judge or a tribunal make that decision for you. A will is an obvious one. You may also wish to do an enduring power of attorney and an advance care directive. Those documents, though, of course, look after you while you're alive. You may be thinking about a binding death benefit nomination if you have superannuation. If you have a trust, you may be thinking about deeds of distribution. You might be thinking about deeds of appointment, basically passing the control of the trust and what happens to the assets within it. Companies, you may be in business with somebody else, a non-family member, for example, and there may be buy-sell agreements that you need to consider. There may be partnership agreements, shareholder agreements. There might be a raft of documents that you need to look at.